Gauteng High Court in Johannesburg will hear President Cyril Ramaphosa's urgent interdict application against former President Jacob Zuma's private criminal prosecution bid. Ramaphosa has launched the urgent bid to, among other things, interdict Zuma from taking any further steps to give effect to his private prosecution against him. The president is also seeking to the court to excuse him from appearing before it on the 19th of January 2023 as directed by the summons. But let's get some analysis on this story, and for that we're joined by Legal Analyst Elton Hart. Elton, a good morning to you, and we are also joined by Advocate Ulrich Roux via Zoom. Ulrich, a good afternoon to you, and thank you so much for joining us. I think, Ulrich, I want to start with you just for a moment. Looking at this case, and I imagine that you've spent some time actually just analyzing, how you think things are going to unfold, not just today, but also on the 19th. But I think let's start with what you're expecting today. Do you expect that the president will be successful in his bid to stop the proceedings, and of course for him not even to appear on the 19th of January?
Hi, good morning. Thank you for having me on the show. Yes, so today's proceedings is an urgent interdict application that has been launched by President Ramaphosa, and he seeks relief from the High Court that the High Court makes a finding that the private prosecution instituted by Jacob Zuma is not cannot be seen as lawful proceedings, that it is an abuse of the criminal justice system, and that an order must be made which prevents the first appearance in the private prosecution of 19 January from taking place. Ramaphosa says in his papers that Jacob Zuma is relying on a nolli prosecute certificate by the NPA, which is effectively a certificate which confirms that the NPA will not be prosecuting Billy Downer and Karen Moore as his support in instituting these private prosecution proceedings against Cyril Ramaphosa. I think there is merit in Ramaphosa's interdict application. I don't think that Jacob Zuma has followed the correct procedures in instituting this private prosecution. The fact that President Ramaphosa's name does not appear on that nolli prosecute certificate should be the end of the private prosecution. He should obtain a separate certificate which stipulates that the NPA will not be prosecuting Ramaphosa in his personal capacity. As we all know, that the private prosecution which he has instituted against Karen Moore and Billy Downer is a pending matter, and it's pending a review by Billy Downer and Karen Moore of whether those proceedings can be seen as being lawful. So I do think that Jacob Zuma has not followed the correct procedure, and I envisage that the High Court will today make the same finding.
Elton, I want to bring you in here. Do you agree with that the former president may not have followed the correct legal procedures? But as you answer that, I think let's bring this one in as well. You did see over the past few days the JG Zuma Foundation also tweeting their surprise and dismay that they would be appearing before a full bench today. What do you make of that?
No, obviously, it's the prerogative of the DP of a specific division as to who will hear the matter, and he then places that matter before the specific court. And obviously, you can have one judge listening to the matter or a full bench. It depends on the magnitude, also the complexity of a specific matter. That's why then the DP will make a decision as to who he thinks or sees has the necessary skill, knowledge to actually hear to a matter. Obviously, in the following of procedures by the former state president, I think there were various other ways that he could have most probably brought the current sitting president also or joined him to the criminal proceedings, the private prosecution that are currently happening, if there was sufficient evidence. Obviously, if the current president feels that the nolli prosecute certificate issued by the NPA was not directed at him, it was at Billy Downer and Karen Moore, and hence he's bringing that urgent application on that basis to say, listen here, there was not specifically a certificate and there is some shortcomings of that certificate pertaining to me, hence the procedure is not lawful. But obviously this is a point of law, and obviously it leads to interpretation. How will the judges hearing the matter interpret the law? Obviously there is merits. For me, I've looked at there can be merits to both sides depending on how you argue the matter, and also who the judges listening. Are they persuaded by your argument? So that is also so, because this is also human nature that will kick in here. So we cannot out and out say that the current president will be successful and the former president will be unsuccessful, because we've seen judgments where we think, okay, this is going to go that way, and then the court does that and just totally overturns a opinion or a thought that we had. But for me, on a balance, it looks like 60-40 in favor of the current president with the application.
Okay, that's an interesting one. I want to go back to the original sort of allegations here that are being made by former President Jacob Zuma, wherein former President Jacob Zuma has essentially accused the president of being an accessory after the fact in his case against State Prosecutor Billy Downer and journalist Karen Moore. Ulrich, let me bring you in here, and I think what I also want to get is really just I suppose an opportunity for us to educate ourselves about what an accessory after the fact would actually mean, and does that sort of argument stand in court? Does it put a good argument on the table?
No, in my opinion, it's a lot of nonsense, to be honest. I think we need to call it for what it is. He's essentially saying that President Ramaphosa, as the president of South Africa, should have taken the required steps to ensure that his medical records were not disclosed by a prosecutor to a journalist prior to the matter being heard in court. But once again, his case is doomed from the outset, because he has not laid a formal criminal charge against Jacob Cyril Ramaphosa in that respect. He's merely relying upon the nollie prosecute certificate that was issued in the names of Billy Downer and Karen Moore. And accordingly, in my opinion, his private prosecution of Ramaphosa is doomed to fail from the outset, because he should have first laid a criminal charge and then obtained the nollie prosecute certificate in Cyril Ramaphosa's name. Then he could have proceeded with his private prosecution instituting it. But, accessory after the fact, I don't think there's any merit in that. He's essentially saying that the fact that President Ramaphosa did not get involved in this means that he's an accessory, and there's no intent proven there. There's no negligence proven there. There's in fact no duty on the president of the country to get involved with the National Prosecuting Authority and the media. We of course have our separation of powers doctrine, and exactly for that purpose, so that these different organs of state can remain independent and objective, and there's no duty on President Ramaphosa to have said to Billy Downer, listen here, what you did was wrong, or to Karen Moore, what you did was wrong. So I think that's a lot of nonsense.
I'm starting to wonder if there's a question to be looked at here around the quality of legal representation and legal advice given to either one side, and I'm not going to speak for one side or the other, but essentially where you've got words like unlawful summons. I mean, Ulrich, you've used the word, it's a load of nonsense when we talk about the allegations of being an accessory after the fact. I mean, is there a concern here that perhaps in one side or the other, there might not be the best sort of legal advice given to one of the role players here, Elton?
No, obviously, if one looks at it, and obviously if one looks at courts specifically, courts and if you talk about the High Court, the uniform rules of court still applies. So one needs to look at what should be in a summons, and then you check, have they met the formal requirements for it to be accepted by a judge or a group of judges. So one needs to look at, and that you will find normally in the uniform rules of court. Yeah. And also it's guided by the Superior Courts Act. So, and then you still have also the practice directives for a specific division that you operate in. So when we talk about is the summons lawful or unlawful, it's like more or less is there defects in the actual court document that was issued. And if there's defects, you are from the get-go doomed that you cannot proceed on that document because the document itself is defective. Then one looks at now, and Ulrich alluded to the fact that here it was initial criminal charges against Karen Moore and Billy Downer. And for me, what I think most probably is that if they have ever actually gathered evidence that the president committed or omitted to act in a certain way, and there's a constitutional duty on him, then if there's a criminal case already pending, they can actually join into the proceedings and not necessarily go and rely on a nollie prosecute certificate where only evidence was produced for Bali Downer and for Karen Moore. So then maybe there is where the president's problems start now to rear its head. And I think looking at it, then you'll have problems actually now coming to say that the certificate can be actually transferred. And I heard that the Jay-Z Foundation, at some instances, they were tweeting and they were also making statements around saying that in the affidavit, in the initial complaint affidavit, they mentioned the president's name, but I haven't had sight of the president's name being mentioned there. So for me, there's the gray areas that we also need to sort of have step into.
Yeah, Elton, I mean, there's so much to talk about, and I think a lot of it as well we can unpack after we see those proceedings. It looks like things certainly have kicked off at the Gauteng High Court in Johannesburg, so let's dip in and listen into those proceedings now.